I'm Charles Goldstein, your advocate at work, advocateatwork.com. Today I'm going to talk to you about two concepts that are very popular in the employment world because they are a way that employers have devised to paper files before terminations. They are called PIPs, as in Performance Improvement Plan, or CAPS, Corrective Action Plan. Now, these are imposed by an employer when there is trouble with an employee, or for some reason the employer has decided to get the employee 1 foot out the door. Truth be told, this 1 foot out the door method means that the employer is essentially papering your file so that they can create documentation that they'll need in the event you're terminated to justify that termination, regardless of what the actual reason might be. It might be you blew the whistle on an unsafe practice by the employer. It might be the manager is unhappy with you and decides to do this as a way to justify a termination. If you're being subject to a performance improvement plan or a corrective action plan, it's important to address it early on, presenting yourself to put your best foot forward. Sometimes that involves consulting with an attorney just briefly to understand what's going on, what might happen in the course of those plans. And then, as any conversations that happen with your employer, record them. It's legal in Minnesota to record a conversation as long as one person knows the conversation is being recorded. Now, you're documenting what happened for a court proceeding or for playing for your lawyer. Many uses can be made of tape recordings of those conversations. Now, if you're called to HR, tell them you want an attorney to be with you because there's a good chance when they call you into HR, that the game is over and you're very potentially being terminated. Don't sign anything, whatever you do. Make sure you haven't signed receipt of the corrective action plan or the performance improvement plan, because you need to, out of that emotional state that you're in the HR office, look at this as objectively as possible with the help of a lawyer and bring the lawyer with you to any HR meeting so that it can be dealt with in the most appropriate manner that best preserves your rights in the event there is a termination, or possibly can result in a plan and negotiation for reinstatement at a different position. I'm Charles Goldstein, your advocate at work, advocateatwork.com.